cause number DC. Is out of order. Put on the record on cause number DC 2016532, Bank of America versus Regions Bank. Counsel, make your appearances.
This is Hamilton McMenemy. I make an appearance on behalf of defendant Weldon Hanson.
Okay.
And I'm Alan Scheinthal on behalf of the plaintiff.
All right. Tell me what's going on in this one.
Well, Your Honor, we think that for several reasons that our motion to dissolve should be granted. One of the early reasons is that 663A was never complied with. There was no notice to defendants of anything about this writ of garnishment, which, according to the cases that we've sent into the court a few minutes ago, there's no exception to the rule that has to be served upon the defendant, regardless of what else is happening. We have several other matters that we think will grant, that will enable the court to grant a dissolution of this also. The second reason is that there are three subsections of 63A that apply, and we believe that that will show that the court should grant the dissolution as well. We have cited several different cases in the in our motion to dissolve, which we believe back up each piece of our reasons why the case, why the garnishment should be dissolved at this time.
And those are challenging.
Yes.
Those are challenging.
Someone's talking. I can't hear what they're saying.
Just a second. Say that again.
Those aren't challenged.
Right. Right.
I apologize. I can't hear whoever's talking. I hear somebody talking, but I can't hear them.
Yeah,
Who is
my
that?
legal assistant did a lot of work on this, and he was trying to say that that all those reasons for the garnishment are challenged in our motion. And we think that because the opposing counsel did say that he was representing the defendant, the plaintiff, whereas in fact he was representing a different company, Star. Let's see, what's the name of it? I don't know why I can't remember it, because it's, in other words, Bank of America is not involved in this case because Mr. Scheinthal filed an assignment of the case to a company called Fed Star.
I guess I'm not exactly. I've read your briefing, and I kind of hear what you're saying, I guess, but I'm not sure I fully follow what you're saying. That the reason we should dissolve it is that your client did not get notice of the original garnishment. Is that your essential argument?
Well, there's two reasons.
No.
One is my client never got 663A, which is required notice of the writ. There are cases which I supplied the court this morning that clearly say that there's no exception to the rule that has to be supplied. So
You said 663 or 63?
663.
Of what? Because it's 63.01 is the Civil Practice and Remedies Code section on garnishment, but I don't know
Yeah.
what
Texas Rules of Civil Procedure 663A requires, it says here, actual knowledge or voluntary appearance by the debtor even is insufficient and does not waive Rule 663A's requirement, service of the writ and all the papers having to do with the writ. And in this case, the plaintiff, neither Bank of America, if you want to say they're the plaintiff, or Fed Star Company, neither one of them were supplied any notice of the writ to my clients, and I've got my client standing by to testify to that, to the non-service of any kind of thing having to do with this garnishment. And then secondly, and separate and apart from that, we have several cases cited in the motion to dissolve, which say that the garnishment application shall state the grounds for issuing the writ and specific facts relied on by the plaintiff to warrant required findings by the court. So the statutory requirement is an affidavit that meets certain requirements. In this case, the affidavit by Mr. Scheinthal, does not meet the requirements of the affidavit.
All right, response.
Yes, Your Honor. A couple things. Going first to the notice. I've got the notice here. The notice went out to Mr. Hanson on December 10 of 2020. The notice, I mean, I can. There it is.
And my client stands ready to testify immediately that that was never received by them and that got a certified letter at any date from Mr.
McManamy, I didn't say a word during your argument. If you just let me respond.
Okay, my apologies.
Thank you. Your Honor, I've got the envelope that came back, and it says here insufficient address. I've got, this is the address that came back, the envelope for that same notice. I sent out the notice per the rules. It's the same address that this green card was returned by. So, you know, I mean, they're the same address. One came back, one is, you know, one went through. So I don't know what happened on it.
And I want to make sure I'm kind of on the same page as everyone. So this is the notice that allows, that puts the garnishee on notice that his funds have been garnished and allows him to post a replevy bond to allow him to get the funds back. That's the notice we're talking about now.
Or do some other, take some other action. But yes, but
Okay.
it was sent out on.
But it's that section, correct, that you're talking about that talks about the replevy bond?
I think that's correct for his argument, but I think that's what he's saying.
Okay, go ahead.
But in any event, I sent out the notice. I can't obviously control what happens once it leaves my office, but I sent it out on December the 10th. Now, concerning the other arguments.
Let me ask this. Is there a deadline on when he can post the replevy bond by, or what is the, I guess I haven't dealt with this section very much. So they send a notice saying, hey, you've been garnished, you can post a replevy bond. And then how long do they have to post the replevy bond?
Honestly, I haven't had it ever happen in my life, so I've not even looked at the rule in that regard.
Okay.
I don't know.
All right, go ahead, Mr.
Okay.
Sir.
In any event, I'm going to be on the record here. I do not represent Bank of America N.A. I represent an entity called Key Star Capital Fund, Roman numeral #2 LP. I filed an assignment with the court to identify that. In my application for writ of garnishment, I did say in the first paragraph that plaintiff Bank of America hereby applies for a writ of garnishment after judgment. It says that. It says that completely. However, I don't represent them. I do represent Keystar. Throughout the rest of it, my belief and understanding and argument is that the plaintiff in this case is now Keystar by way of an assignment. In the affidavit attached, I did say I'm the attorney for plaintiff, that plaintiff owns a judgment. There is a judgment that was rendered August 28, 2015 by this court. That judgment is final and non-appealable. No supersedious bond has been approved and filed. The amount of the judgment is $99,962.49. All these facts are true and undisputable. I'm not aware of any assets that defendant has that are sufficient to satisfy the judgment. These are the facts that I've pled in the motion. I know because Regions Bank filed an answer, there's about $30,000 in a bank account. And that's the only assets that I'm aware of that exist based on the fact that there's a final judgment and I'm trying to collect that final judgment on behalf of the plaintiff in this case.
So, sir, I'm just kind of looking through the whole file at this point. I'm sure that some in here somewhere, but I don't see anything in the original application or I guess what was the next thing I looked at? Or in the motion for default judgment that indicates that there was an assignment involved. I've dealt with hundreds of cases where it's usually.
Now you can chime in about the signature line.
I'm going
Okay.
to, okay.
When the judges, okay, wait, let me finish my question. Somebody just started talking and then you started talking. So let me finish my question so you kind of know where I'm going here. So I've handled a lot of these types of cases where you have debt buyers that come in and buy the debts off of, different groups or different entities. But usually there's an assignment in the initial application. I don't know that I've dealt with this in the context of a garnishment. And so I guess where does it show that there is an assignment? What document or where do we have something that shows that there's been an assignment and what the assignment is and how you have the ability to go forward with this?
On October 22, I filed a notice of appearance of counsel.
October 22. The case wasn't filed till November 4th.
Well, the garnishment was not filed until then, but I've made sure before I did anything that there was notice out there of who I was and what I was doing.
How do you file a notice before you have a lawsuit?
No, I'm sorry. There was a judgment in this case rendered in 2015.
You mean in the underlying case?
Yes, in the underlying case.
Okay.
I filed this action in the underlying case.
Okay.
On October 22 of 2020, I filed a notice of appearance to let the court, as well as in this case, I sent a copy to Mr. McMenemy advising him on October the 22 that I was the attorney of record for the plaintiff by way of an assignment.
And okay, so where's that in the, so okay, this is what my confusion is. So right now, this case is being resolved under cause number 2016532, Bank of America versus Regions Bank. Within that cause number, where does it show that there's an assignment?
Okay, so I see what happened here now, Your Honor, and I'm looking at it, and that may be my error here. I filed this original application for garnishment in DC 1404816, which is the original case of judgment, the one that was rendered in 2015. I filed the garnishment in that same action.
And Your Honor, what we want to point out is that in every case, all of his indications on all of the cases and all the filings he's made is that he's representing Bank of America. And since he's not representing them.
So let me share screen real quick, because I think this is what you're talking about. So you
Yes.
originally put this in DC 144816, is that correct?
Yes.
And then the clerks, I guess, crossed this out and put it into a different cause number.
And that's where I guess that's where I am. I obviously didn't pay attention to that specific cross out by the clerk's office.
Okay.
But I knew that I had filed it. I knew I had filed it because Mr. Hamilton even acknowledged the fact. Mr. McMenemy acknowledged the fact in his response that I represented Keystar because he knew it. And I guess I was filing this under the impression, well, I see what happened now.
Your Honor, we filed this morning a reply to his response, which pertains to all of this. And we're thinking that his response to our request for dissolution doesn't come up with any authority or anything else, and still doesn't say anything about.
Let me just say this. I've been looking through the file. So there was an amended application for writ of garnishment after judgment that includes Keystar Capital and has an assignment.
That document has not been served.
Okay. And Your Honor, every one of his signature lines refer to him representing the plaintiff Bank of America. Never does he have in there anything about representing Keystar.
Motion to default judgment and motion for summary judgment only.
The default judgment, summary judgment, all of it is still says he's representing Bank of America.
Signature line.
The signature line is he says he's representing plaintiff, and the signature line says attorney for plaintiff,
Bank of America.
which then is Bank of America.
He said,
But he doesn't represent Bank of America.
This is a unusual situation, and I don't know that I've ever dealt with this. So, so you filed an application in the original cause number, and I guess in the original cause number, you had filed something like a notice of appearance with an assignment attached. Is that right?
I filed the notice of appearance to make notice to the court and to opposing counsel of my existence as the attorney for the new entity by assignment.
But then all the following documents he represents says he's representing Bank of America.
I get that.
Your line says Bank of America.
Wait. So, and then you filed the application. The application says it's filed in the name of Bank of America. And then you file a default judgment, I guess, and a summary judgment on the garnishment, all in the name of Bank of America. And then subsequently you file an amended notice of garnishment and include the assignment, but that's never been served. Am I getting the history here correct?
Yes.
So, I mean, all right, well, that seems kind of problematic. So, is there a basis?
No, Your Honor, we think the important part is that there are facts in his affidavit that are not correct, because he says in there that he's representing Bank of America.
can't support the writ.
And it can't support a writ if it has anything untrue in the affidavit. That's key in every one of the cases you want to look at. we've got the El Paradico Inc.,
So,
which we sent in to you.
so sir, you just submitted some additional case law today.
Well,
to the court,
we sent you the copies of the El Paradico case and the Wilson case, which were cited in the original motion to dissolve, because I thought that the court could have those for reference.
And do those cases say that if you file the garnishment in the wrong name, that is a basis to dissolve the garnishment?
Yeah, and it says that if you have any error in the affidavit, then that's both of them are grounds for dissolving the writ.
Mr. Scheinthal?
Your Honor, I can acknowledge the fact I'm not going to deny it. It's right in front of the court's face as well as everybody else's on these screens. There are some irregularities. I see it. I understand it. And there's not much more for me to say concerning it.
Okay.
At this time.
Are you contesting the motion to dissolve at this point, given this issue, or what is your position on that?
I believe in calling it as I see it, Your Honor. I see that there are some irregularities with the original application that are concerning, both for me when Mr. McEmaney filed his motion, as well as, my subsequent review of the file.
I'm not sure what that means. So I'm going to go ahead and grant the motion to dissolve.
May I make one statement before you do? If that's what you're intent on doing, I don't have, I'm not going to sit here and appeal. I don't think I have any grounds. But what I would say, Your Honor, is that I've looked at the order that's prepared, and I think the order that's prepared is a little overdone, and it's asking for judicial opinions on matters that are not before the court. And if the court is inclined to dissolve, I think the order should say dissolved and nothing further, that anything else is asking for more than what has been pled for.
And of course, we pled that the affidavit represent, but that's fine. We'll take the disillusion and go with it.
Okay. Okay, let me see if I can get this printed out. So I'm just going to kind of cross out the part that's probably superfluous. That's one.
We can send in
Do you want us to send in a?
Yeah, why don't you send us in a clean one?
Yeah.
May I get a review of it before it's submitted, since I have questions?
Certainly. Yes, absolutely.
Yeah. Why don't you guys do that? Just get me an order, preferably with an agreement as to form. And I guess you may have to refile, serve this and get it refiled and everything. So.
Yes, sir.
Judge, before they're dismissed, can I give Mr. McMenamin, can you spell your name for me? It's not listed on the docket.
Okay, it's MC, capital MENAMY.
All right, guys. Thank you so much. You guys be safe, okay?
Thank you. You too, Your Honor.
Thank you, Your Honor.
Our next case is Axel v. Axel. Is there anyone here on that case?
Hello, Your Honor. Yes, this is Donna Yarbrough. How are you, Your Honor?
Good morning.
Good morning. My client should be on here.
Okay. And have you given notice to the other side?
No, Your Honor, this is ex parte.
I'm not sure why. I'm looking at the system. I don't see that the petition has been scanned yet, so I can't see what this case is about.
Oh, you want me to give you a brief explanation, Your Honor?
Yeah, that would be great.
Okay. My client, her name is Yasmin Axel, and she's the granddaughter and power of attorney for Malva Axel. And so she has filed a plaintiff's original petition application for a TRO and temporary and permanent injunctive relief. Her grandparents are, the grandfather recently died from COVID. The grandmother's 95. They're both Holocaust survivors. And my client's father, who's Melva Axel's biological son, has stolen money from her, continues to break into her house. He's threatening her caregivers and her and my client. And because my client's grandmother's 95, she is authorized Yasmin, her power of attorney, to file this lawsuit on her behalf. Basically, because they are Holocaust survivors, I didn't know this existed. There's a claims committee, and the German government has to pay reparations. In fact, the grandfather, his name was John, Jan Axel, received $38,000 this last October. And it appears that both Dove Axel, the biological son, and Esther Axel, his wife, for both my client's parents, are attempting to break into Mrs. Malva Axel's home and steal her identification document so that they can get the rest of these reparation funds. And they have physically harmed Malva and are threatening her caregivers. And without this, if they're not restrained, basically, they're going to take her identification information and they'll be able to take the rest of this money. And the money from these reparation funds pays for 70 hours of a private nurse per week for this grandmother. And basically, we're just trying to prevent him. He's making, he's acting like he is her power of attorney and trying to get her records and get into her accounts and steal stuff. So I have my client, Your Honor, if you'd like testimony.
I don't allow testimony in TROs, but why aren't we giving the other side notice of this?
Because they're physically threatening and breaking into my client's grandmother's home. And if they had notice, it would be even worse. That's why we had to get this, because they've physically shaken her. The dad is an asymptomatic COVID person. He continues to break into the house. He gave the grandmother COVID, who's still suffering from it. He gave the caregivers COVID, and he refused to get tested. They've stolen property, shaken this woman. If we gave them notice, it would make it even worse for her. So that's why we're just trying to get this ex parte and serve it upon them. They basically, Your Honor, it's in the affidavit, but the danger to my client's grandmother is they stole all this money that's in the joint accounts. She tested positive for COVID. If they continue to break into the house and they push past the caregivers and they're searching for something, and we think it's her identification documents to prove that she is a Holocaust survivor, if they do, my client's grandmother will lose her funds and she won't be able to pay for the caregivers, won't be able to pay for her apartment. They've already stolen money from her. She's called APS, she's called the bank, but there's no one who's going to file a lawsuit or be able to physically refrain them from breaking into the house and stealing this information without a TRO from you, Your Honor. And the father continues to break into the house. So these people, the caregivers, are trying to quit. Some have already quit. And while the grandfather was alive, the grandfather fell down and broke his hip, and he allowed him to stay there without any care. He gave him medicine, so he could have died until a caregiver got there. So we have to have some way to prevent this man from physically harming Malva or my client or any of the caregivers. We're asking that you restrain him from making representations that he is the grandmother's power of attorney, or from trying to access any of her financial accounts or safe deposit box. We're asking that you restrain them from contacting the claims committee or from continuing to possess any of her financial information. We're asking that, and if they do have any, you require them to.
Let me just say this, I'm not talking about the merits of this particular TRO. The question I have, and this is just based on years of experience as a judge, is that I'm not questioning that, this may be true, what you're saying, but I'm only hearing one side of the story. If I grant a TRO, it would be extremely limited because I haven't heard their side of the story. They may have a equally valid position. I don't know. I haven't heard their side of the story. So you kind of have two choices. I can give a very limited TRO saying that they're not allowed to assault the grandmother, or they're not allowed to take funds from the grandmother. But the restrictions you're asking for, only hearing one side of the story, are just way too broad. I may give that after hearing both sides and giving both sides an opportunity to hear them, but it's not fair. I mean, I can't tell you the number of times that until I finally kind of figured this out as a judge, where people have come in and said, hey, look, this is what's going on in a TRO. I did it ex parte, and then there was an equally valid argument, if not better argument, on the other side. And so
I understand.
Would you prefer to have an extremely limited TRO right now, or do you want to put the other side on notice and have this at another time?
No, Your Honor, we would like an extremely limited one. There are several, I think 3 police reports, and there's an APS report, and I was not able to get those in time to provide those to you, Your Honor, but if you could give us an extremely limited one, that would be great, because if we give them notice, they will harm Malva and or my client.
Okay. Peyton, I'm printing something out. Can you go grab it for me? All right, let's just kind of figure out what we can do without notice.
Thank you, Your Honor.
Now it's frozen, great. My whole computer's frozen, that's not good. Great. Rhonda, on this case, can you print out the TRO and just bring it to me, or give it to Peyton to bring to me? So let me share screen the TRO so you can kind of, I'll tell you what I'm probably willing to do here without notice. So for like number 1, I would probably do that, but I would put a modifier that says until you said that they're currently positive for COVID, or they just had COVID in the past?
I don't know if they're still, I think that the father is a carrier, like he is asymptomatic and he refuses to get a test, but he had sent an email, a text, both him and Esther Axel, showing that they were positive. So I don't know if they're still.
When was this?
This was recently, Your Honor, like within the last, I believe, week or week and a half.
Okay. I'll put on the first one, I'll just say until, and is it both of them that have the positive test, Dove and Esther, or just Dove?
Both, Your Honor. And the grandmother just is, I think she just got out of the hospital from it. But Your Honor, we just don't want them coming into the residence because the caregivers want to quit because they're. physically aggressive.
I've given you an option here, which is I'm going to give you extremely limited here. I haven't heard the other side. And so if you want me to do this as a extremely limited one, I can. And so what I would do is I'd say that they can enter. They're not allowed to enter until they receive a negative COVID test.
That's
So,
great, Hunter. We'll take it. Thank you.
Number two, we're not going to grant because I don't know the other side's position on that. Number three, I'm not going to grant because I don't know the other side's position on that. Number four, I'm not going to grant because I don't know the other side's position on that. And then number five, I don't know the other side's position on this because all of these are information that I just don't know the other side's position. So that's all I can give you is number one and as modified.
Okay, well, Your Honor, what about I know three, you're saying you don't know the position on that, but I mean, my client is currently serving as a power of attorney. So
I don't know if they have a more recent power of attorney. I mean, again, I don't know the other side's position on this. So I want to make sure that that your client is not injured in any way. And that's why I'm requiring them to get a negative COVID test before they come in. But other than that, I don't know the other side's position. There may be a newer power of attorney. They may have rights to all of this. Again, I don't know the other side's position on this.
okay.
Do you still want the TRO? Because you get
Yes,
one bite
Your
at
Honor, I
this.
do. Yes, sir.
Okay. I'll just require a $50 bond.
Thank you, Your Honor.
$50 bond. And this will expire on the 22nd day of February at 5 p.m. We'll set the temporary injunction hearing on this case. Set February 22nd of 2021 at okay, we're setting the temporary injunction February 22nd, 2021 at 3 p.m.
Thank you, Your Honor.
All right. Okay, I'll have that scanned today. Ron, if you don't mind coming and getting that, and you'll have to pay the bond for it to become effective. So you'll need to work that out with the trust office. Thank you so much, and you be safe, okay?
Thank you, Your Honor. Bye-bye.
Okay. Okay. All righty, let's do this. All right, is anyone here on the Martin v. RBR maintenance case? Anyone here on that case? Can you all hear me?
Sorry, Your Honor, I believe I was
Is
muted.
there, hello? Good morning, Your Honor.
Good morning, guys. How are you?
I'm here. I'm good. Your Honor, it may save time that the opposing counsel submitted the motion. However, I've spoken to my clients and we have no objection at this time. I don't know if that would streamline the process this morning.
I'm looking at, okay, it's a little confusing. So are you guys here on the Martin versus RBR maintenance case?
Yes, Your Honor. Christopher Lawless for RBR Maintenance is here.
Okay, it looks like it was taken off of the docket. So let me pull that up real quick so I can find out what case you're talking about. Or actually, so I can look at the documents. And kind of explain what's going on in this case.
Your Honor, this is a simple motion to lift the stay and confirm an arbitration award filed by defendant. And plaintiff's counsel did tell me this morning through chat on this Zoom that they're unopposed. So it's an agreed motion to lift the stay and confirm the arbitration award.
Okay, let me pull that up. Okay, I found it and I will print it out and sign it now.
Thank you, Your Honor.
All right, thank you guys. You guys be safe, okay?
Thank you, Your Honor. You have a good day as well.
Have a good day, everybody.
Is anyone here on the Williams versus Varela case? Williams v. Varela.
Good morning, Judge. Jim Ellman on behalf of defendants.
Your Honor, Jeremy Allman for the plaintiffs.
And Your Honor, William Davis for the defendants.
Okay. All right. This is a motion for continuance, correct? Is that right?
I'm sorry, I couldn't hear that, Your Honor.
Is this a motion? This is a motion
Yes.
for continuance?
Yeah, it's our agreed motion to continue the case. We were looking to get the case continued from a trial in July to a date in November.
I mean, this is a pretty old case. Why, I mean, we may not be able to do trials in July, but we may. I mean, it's kind of up in the air at this point. Why do you guys want to do this?
Well, I think both sides have always wanted to depose the parties in person, Your Honor. Obviously, due to COVID, that's kind of delayed everything. I think we're getting to the point.
That's not a basis to continue a case. Unfortunately, we have way too many cases at this point. The emergency order that the district judges have adopted, as well as all the Supreme Court orders, clearly say that you guys are allowed, in fact, strongly encouraged to do that. So I don't continue cases on that basis. So is that the only basis?
Well, it's not the only basis, Judge. All discovery has basically been kind of stayed due to
the court has stayed this discovery?
No. The parties have. The parties haven't been actively pursuing discovery. We have some upcoming dates. We have a mediation deadline. I believe that's in May, and we have not gotten that scheduled. We probably could get everything done in time, but I think the plaintiff and us, when we discussed it, we didn't think, like Your Honor said, that the trials would be proceeding in July. So that's why we were looking to get a certain date in November.
I don't know if they're going to be continued. I mean, you have all these new vaccines coming out. The numbers are going down now. I'm basically, you may end up being right that we don't have trials, but you may, July, I think is, I don't know, 50-50, but at least a reasonable possibility that we'll do that. So you guys just need to get this case teed up and ready to go. And I don't see a basis to continue it at this point. If we get closer, just understand that if we're able to try cases in this case, given the age, we would probably be, this is a case that would be in line to be tried if we're able to try cases in July, because of the age of it. So you guys need to start conducting discovery and get this case ready.
All right, very well, Your Honor.
All right, guys, anything else?
No, sir.
Okay, good luck, guys.
Thank you, Judge.
Thank you, Judge.
Okay. Next case is Hughes versus Anderson Homes.
Yes, Your Honor. Michael Ricky on behalf of Kristen and Craig Pass.
Okay.
I filed this motion continuance. We've been trying to conduct discovery since November and haven't received a response. And I've reached out to all defendants since early September. And the last response I got was late September from anyone. Ms. Ocker, I see, is here today. And we just need time to complete discovery. Again, I know mediation really isn't a grounds for a continuance. I think this case can settle if we had open communication, as well as I have 3 pending motions before the court, one being a summary judgment based on deemed admissions. So for those reasons, I think we have grounds for continuance. Thank you.
All right.
Honor, Ms. Oker here for defendant John Larson and I think American Real Estate Investment. This case has a default judgment against other defendants, and we've basically been waiting for it to be severed so that the judgment can be collected against those who already have a judgment against them. That motion was just filed in January, and we are unopposed to that motion as well as being unopposed to the continuance.
Okay, let me just kind of look at this. So you have a non-jury trial tomorrow. Continuance. You said there was a severance motion that.
Yes, Your Honor.
And it looks like there was also a non-suit. Is that correct? Has the non-suit been signed?
I do not believe so, Your Honor.
Okay, let me just kind of share screen. Okay. Rhonda, if you could go to this, we need to print out some of these orders. I'm not sure. We're obviously not getting all of these. So January 13th, there's an order of severance. He said that's agreed to. That needs to be printed out. That needs to be signed. Is that correct?
Yes, Your Honor.
Okay. And then there's an order of summary judgment, but that hasn't been set, it sounds like, correct?
Yes, Your Honor. I wanted to make sure we had 21-day notice to provide to all the defendants that includes.
And then there's the order of continuance that's on January 16th. That needs to be printed out, Rhonda. And then there's an order of non-suit for January 26th, and that needs to be printed out. Ron, did you get all of that? So what do you still need to do to get this case ready for trial?
I would like to have some discovery. We haven't had any discovery. I sent it over in November, and we have no responses on file from any defendant.
Yeah, it was our understanding that they would be moving to sever and collect against the other defendants, which we would get a credit for. So that's what we were waiting for.
But why didn't you, did they send you discovery and you just didn't answer it?
I think what we had a discussion of is that they would be collecting the judgment against other defendants.
Is that correct?
Your Honor, I don't remember that discussion. I have an email from Ms. Ocker late September stating that she was going to get back with me about a settlement. And then communications fell apart there.
Okay.
So did you ever tell her that she didn't need to answer discovery?
No, Your Honor.
Okay. Well, Ms. Ocker, how quickly can you answer discovery in this?
I don't know. I don't even remember the discovery. I was pretty much out from September through December. I just remember a discussion saying we're going to sever and go after the other defendants to collect the judgment, so that my client's not paying a bunch of fees for basically a judgment that's collected against somebody else.
Response?
Your Honor, that communication never happened about the sever and collecting from someone else. So the communication that me and Ms. Ocker had was that we were going to talk about settlement, and then just like in any case with multiple defendants, you know, they can divvy up who pays what then. That's not our burden, not our duty at that point.
Okay, well, what type of discovery did you send in this case?
Request for production, request for admissions, and interrogatories, and we still haven't gotten any disclosures from any defendants at this point either.
And are you going to need, so let's just kind of go through this. So you need, I don't know the basis of this, and that's not before me today, on whether or not the objections are going to be waived, or was there a, an extension granted, or what exactly? So I'm not ruling on that issue. I'm just trying to figure out how long we need to get this case. I'd like to get this case tried relatively quickly, because it's a non-jury, and we're just gonna, once the jury trials start up again, whenever that is, we're just going to be inundated with those cases. And so I'd like to get this tried in the first half of this year if we can. So that's why I'm trying to figure out what still needs to happen.
Your Honor, if we could get a setting in May, early May, that would be perfect. I want to get this case tried and over with as well. That'd give us time to have discovery conducted, our motion for summary judgment hearing heard, as well as try to get to mediation before trial.
I would request not early May because I'm up for election on May 1st. But I guess.
What are you running for?
Carrollton City Council.
Oh, good luck.
Thank you. Because if the defendant is there and it's not judgment proof and I didn't file an answer, making my client go and hire expert witnesses and pay me to actually defend the case, to get a judgment based on the same facts and circumstances seems very unfair and inequitable. We prefer to see some sort of attempt to at least collect against the other defendants who didn't even serve an answer. So settlement, why we don't feel the need to pay the full judgment when we don't know what the collectability against the other defendants are, because these are not related entities. I represent related entities, but the other entities are not related to us. So that's where our issue has been. We will pay the mediation fee and we'll go to mediation, but if there's been no attempt to collect, not even a motion to sever for an attempt to collect against those who didn't even appear, I don't see settlement being very likely, as the money will not likely come from my clients when there's others out there who may be perfectly capable of playing the judgment and just aren't doing it.
Response to that?
Your Honor, we have a motion to sever on file. We are attempting to sever.
And we are unopposed. I didn't mean to interrupt you. I'm sorry.
And we talked back in September, me and Ms. Ocker, about talking about settlement to even avoid paying mediation fees, going through discovery, everything, trying to settle this case first and foremost to save everyone fees. Now, my clients, incurred a ton of fees trying to get some answer from anyone. And so at this point, I'm happy Ms. Ocker's here, and hopefully we can get something done. Hopefully this sever and we can try to collect, but I think we can settle this case. If not, the motion for summary judgment should resolve the case.
All right, I'm going to go ahead and set this. I want to give, I don't want to I've been through elections, so I know how busy they are. I want to give Ms. Ocker some chance to kind of recover after that. So I'm going to set this on May 25th, 2021 at 9 a.m. And I granted the severance. I just want to make sure, because this has been an issue in a lot of our severances lately, that people are not paying the severance fee, I guess maybe because this is all handling remotely. So I've added a sentence in. I actually had a big issue in another case where this was an issue. The severance does not become effective until you pay the severance fee. So make sure you pay the severance fee, get a new cause number, and then make it clear. You can just file a motion to sever. It's a little unclear in the case law whether or not that's effective. So make sure that you pay the severance fee as set by the Dallas County District Court clerk. And I've included that in the order. So in case it's hard to read because my handwriting's not great, I've done that. Anything else, guys?
That's it, Your Honor.
All right, and I will work diligently to get that discovery finished so it's not back before the court. Thank you.
Sounds great. You guys be safe.
Thank you, Your Honor. You have a good day.
See everyone. Good luck on your election, Ms. Ocker.
Thank you.
Yes, good luck.
Thank you. I'll get back to you by email
Thank you.
when I figure out how to leave. Okay, here we go.
All right. Nurin versus Catholic Charities of Dallas, Inc. Anyone here on that case? Nurin versus Catholic Charities of Dallas. Anyone here on that case? Okay. ATES versus R Calling Inc. Special exceptions on cause number 205062. Anyone here in that case? Okay. Francois versus Parmenter Realty and Investment Company. Oh, wait a minute. We're really early. Okay. So who's here on the Commissioner Chaudhry? I don't have a hearing for you. Oh, wait a minute.
Yeah, we do.
There it is. Okay. Wildwood. There you go. Your opposing counsel here?
They are not. They set the motion. I don't think they are, but they set the motion for 10 a.m. and we're here, and Ms. Lee is prepared to argue on behalf of plaintiffs.
Let me see.
You had it right there. Right there.
Oh, this was the one we were going to try to do last week, and then I thought Mr. Song wanted to argue this.
Right. They filed the motion. They set it for this time. We're ready to proceed. We've got the video of the January 11th hearing queued up for you, Your Honor.
They've been showing up to everything. Why don't you call them and just find out what's going on?
All right, we'll do, Your Honor.
So you can put us on, go ahead and put yourself on mute, call them and see if they're going to sign on.
Yes.
Okay.